It's a privilege this evening to introduce two leading Caribbean lawyers to a roundtable discussion concerning the recent Caribbean Court of Justice ruling in the Ali and Jagdeo versus David case. We have with us this evening Devindra Kissoon, who is one of the three lawyers that led the legal team at the CCJ and is widely regarded as a prominent commercial lawyer in Guyana. Studying at the UCL and Cornell Law School, he left a partnership with one of the largest law firms in the United States to become the founder of the London House Chambers here in Guyana. He is admitted to practice in New York, London, Trinidad, Barbados, and in Guyana. Our second guest this evening, Senior Counsel Anthony Astaphan, who is regarded as a leading elections lawyer in the Caribbean with more litigated elections cases than any other practitioners in West Indian jurisprudence. He is a door tenant at 3 Hare Court in London, one of the leading chambers there. And he is consistently ranked by chambers and partners as a leading practitioner over the last few decades. He will be more fully introduced by Mr. Kissoon, who will lead the discussions this evening. Mr. Kissoon.
Thank you very much, Kurt. Good evening, Senior. I must tell you, it's a tremendous privilege to have a man like Anthony Astaphan, Senior Counsel, among us here in Guyana. Senior Counsel, it's lovely to have you, and thank you for coming this evening.
Thank you very much. My pleasure.
You know, we had a tremendous storm here this morning, and the calm has come just after the storm this evening, and I hope the weather is better where you are in Antigua.
Well, it is.
Well, Anthony Astaphan, to students of the legal profession in the Caribbean, is a living legend. Not only does he have the most, among the most litigated cases in public law matters in the Caribbean, regularly appearing at the Privy Council and the Eastern Caribbean Supreme Court, but historically, whenever a Caribbean leader, a Caribbean government, or a Caribbean opposition party has a problem, there's only one number that they would have on their fingertips, and that is of Senior Counsel Astaphan. He routinely represents persons throughout the region in those capacities, in elections-related matters, in public law-related matters. He's a public law specialist generally. And as you had mentioned, Kurt, not only is he consistently ranked in chambers and partners and who's legal as the premier practitioner in the field regionally, but he is also considered by jurisprudential leaders in the Caribbean as having the election laws and other related matters at his fingertips. He's a Band 1 rank lawyer, and certainly for us, it's a privilege to have him here. And just a quick search this evening revealed that he has more than 70 cases reported on the database that we lawyers use, LexisNexis alone, which is certainly a feat in these times. So, Senior Counsel, with that mild introduction, I certainly, whilst I'm very familiar with you, for the persons here that aren't, I would love to learn a little bit more about you and your foray in public law matters, and specifically in relation to elections-related matters. If you could tell us a little bit about your background and experience.
Well, first of all, half of what you said about me, I wasn't aware of in terms of the 70 cases and so on, but thanks for that. I actually got into public law representing prime ministers and governments almost by accident, because I started taking on the governments first. And I think they didn't like what I was doing or the rate of my success or what, so they decided to ask me to represent them. And having started to represent them, they have not let go yet. You know, I mean, I'm still doing a significant amount of public law litigation, constitutional litigation, election law litigation as well. I mean, from 1997. And some defamation matters, because once you represent politicians and governments, there's always the necessity of going to court at some time. Always, especially with election matters, as we found out, as we are finding out.
And I've been reading that you recently were noted for representing Denzel Douglas and are now involved in the election matter in St. Kitts. Is that right?
That is right. I represented Denzel Douglas. Douglas Mendez was on the other side. We have an extraordinary relationship. We work together as we did in this one, and in St. Vincent, and we work against each other ferociously, but with no blood being spilled.
Well, that's something that's very rare in our parts, as you could imagine. Election matters are not prevalent here of this nature, and it's a learning experience for all of us. I understand that you and Douglas also studied together at Cave Hill. Is that right?
We did. We were in the same year. After Cave Hill, he went to so you would, and I went to Norman Manley.
And just colloquially, you are a living legend. When you and I were discussing matters, and based on our research, you have litigated more cases of this nature, more than any practitioner that's currently alive in the region. Is that right?
Well, so I've been told, and in fact, I've been asked whether I would consider writing, whether we would be, I would consider, sorry, that's my son charging it, whether I would consider writing a textbook or what on election law, but I'm really not so sure.
As you and most...
Sorry.
No, that's all right. I have 2 young children myself, and I'm fighting desperately for them not to come in the room. So I completely...
Please keep praying.
As you and most Caribbean scholars are keenly aware of these matters that have been unfolding in Guyana, they too have presented much jurisprudential discussion throughout the region as to what has been happening here legally, and the approach taken not only by the courts, which have worked tremendously well in resolving matters quickly, but how the events as they comparatively relate to other events in other Caribbean territories. And I wanted to have a sense as to the events that have led up to the judgment that was recently passed. Are these commonplace in the matters that you have handled?
No, look, I mean, let's be frank. The facts that have occurred, the sequence of events that have occurred in Guyana in relation to this election are extraordinary facts. I don't think I have ever come across anything even close to having to deal with that. And I am not sure precisely why it has been allowed or permitted to be so protracted. But the reason I think is obvious. There's a deliberate attempt to delay the transition from the loser to the winner, from the winner to every conceivable legal challenge is being thrown up. But all have been, in my view, entirely misconceived, especially in relation to the recount. Once I was told about what it is that the chief elections officer had done or was trying to do with GCOM, it was for me stunning, because all of the allegations that were being raised, I could not find, and we could not find any legal basis for them being raised during the recount under the legislation of Guyana and so on. But worse is that every one of the allegations that were being raised in other parts of CARICOM, these allegations were dealt with within the exclusive jurisdiction of the High Court under the Constitution to determine the validity of an election or the validity of a ballot or the qualification of the person passing the ballot, whether it's fraud, whether it's whatever have you and so on, have always been dealt with by election petitions. And I found it, I think, bordering on the absurd to suggest that within the structure of the Constitution of Guyana, that a chief elections officer who's appointed by GCOM, and GCOM is not part of the judiciary of Guyana, whatever legislative powers they may be vested in, could make a decision to disenfranchise over 100,000 voters in order to say, well, the PPP did not win, the winner was actually the APC, whatever they call, because I, having taken on the objections from one side, without a judicial process or any form of judicial hearing or scrutiny or accountability, came to a conclusion in the middle of the night, so to speak, that the party that in fact won the election had lost it. And it was at that time that I sort of confirmed my commitment to stay on to assist in this matter, because I thought it was an affront to frankly speaking, an affront to democracy in Guyana and in the Caribbean. I couldn't see that being done in any other country in the OAC or CARICOM.
And in your experience, have challenges of this nature, where persons have been acting similarly as persons here, have those happened in your practice and in your career?
My friend, I am not aware of any chief elections officer coming remotely close to the conduct that I have seen in this case. In fact, there is nothing that is transpired in Guyana that I think I witnessed in the Caribbean island. The constitutional provisions and validation of election provisions and representation of the People's Act and so on. What was happening here was an extraordinary event. And I sincerely hope that after the ruling of the CCJ today, that there is no repetition or recurrence in any other island, because it's look, and let's start from the genesis, the recount that took place following the agreement with CARICOM, right? First of all, the observers spoke of, and it's important the listeners understand the context, the election process, the actual balloting of the process of putting your ballot in the box was supervised by numerous electoral observers. Yes, CARICOM, Commonwealth, this one, that one, and the other. They were unanimous in the view that the election process, the counting process was free and fair and flawless. That tells me something as an election petition lawyer, that there were no objections during the election process, the actual voting process of fraud, impersonation, people living overseas, different. Kissoon is voting for Astaphan and vice versa, and that sort of situation. So that was the first red flag. The second red flag was when the observers were unanimous in their position that the problem arose during the count, where there was a separation of reality between the statements of elections and the returning officers' figures for District 4. I think it was a constitution, whatever you call it, District 4. The international regional community were unanimous on these two facts: free and fair elections, no fraud, no oppression, no disenfranchisement, blah, blah, blah. None. But the problem was the count. So there was an agreement for the recount, which I understand the president said he would abide by. The count clearly showed mathematically, as the Justice of Appeal mentioned in the hearing, the quantitative votes were in favor of the PPP. They tried to utilize the motion before the Court of Appeal under Section 1774 to inject the qualitative process, meaning a determination to determine the fairness of the election. By very cleverly, this is not an imputation on the court, but by asking for a meaning as to whether ballots meant ballots, the quantitative ballots by which somebody normally wins an election, or the qualitative process of arriving at the ballots. Now, I don't think people appreciated the significance of that, because had that decision been upheld, had the Court of Appeal, had the CCJ ruled that the Court of Appeal did in fact have jurisdiction, do you know what that would have meant? It would have meant a single person appointed by whoever to be the supervisor of the election or the chief elections officer would have determined for the High Court under its exclusive jurisdiction, or would have determined in place of the High Court in the exercise of its election jurisdiction, the result of the election by himself determining that ballots should be rejected because of the usual irregularities, fraud, impersonation, and so on. that would have dug an enormous hole into the constitutional framework of governance and deciding the processes of election. And that is the fundamental principle out of the judgment of the CCJ today, that you cannot leapfrog the two cleansing processes made for the representation in the People's Act and validation and the Constitution. There must be a determination of ballots to be invalid at the preliminary count. That never happened. The recount is a different kettle of fish altogether from that process. But once that's done, you cannot seek to set aside a ballot on any basis whatsoever, particularly fraud or impersonation or what have you, other than by way of election petition, vested exclusively in the High Court. And that would have been, had the CCJ ruled differently, my dear friend, that would have been an election result that would have been determined in complete violation of the structure of the Constitution and the judicial process required for the independent High Court to make a determination as to whether the election was free and fair or not.
Mr. Kissoon, I'd like to bring you into the discussion now, because I think we've provided good historical context to why we are where we are today. Could you tell us about your own involvement in the case commencing at the Guyana Court of Appeal, and in turn explain what the CCJ ruling today really means?
Well, we were retained by the applicant appellants in this matter to handle the defense of the matter that was filed by Ms. David, and did so in the Court of Appeal, and thereafter were retained to file the matter at the Caribbean Court of Justice, which we did in a few short hours. I was supported with great help and led by a team out of Trinidad and Tobago, led by Douglas Mendez, Senior Counsel. And a special thanks out to Theresa Haddad Muraj, Rishi Das, Clay Hackett, all of whom did a lot of the heavy lifting in putting the entire case together. And of course was led here by Anil Nandalal in putting the case forward. When the Court of Appeal ruled, we decided, of course, that this needed to be immediately addressed, though we felt that the purview of still deciding what the elections result would have been under the umbrella of GCOM. During the hearing of the appeal, however, there were certain things that occurred that, as we have the benefit of senior counsel with us, I just wanted to get a sense regionally. There were many comments that were placed in regional press. There was an advertisement in the Trinidad Guardian, letters written in the Gleaner, things that are placed throughout the Caribbean, speaking about matters that were before the court. And Senior Counsel, I wanted to get a sense from you as to, again, what would be the normal course of conduct in dealing with these sorts of matters.
Well, my experience is, right, that in some parts of CARICOM, politicians would win a case and celebrate the court. Then they may lose it in the Court of Appeal and condemn the court. But I think this is the first time that I have seen a concerted press campaign between leading up to the hearing by the CCJ and the delivery of its judgment in a manner calculated to cast or to pigeonhole the CCJ in a way that I found embarrassing and obscene, because we have to trust our regional institutions. We have to trust the CCJ. They are an integral part of the rule of law for Dominica, for Guyana, and others. And this constant bombardment of advertisements and the recycling of the lawyers' arguments in the newspaper, and press officers from within the offices of the executive putting out this, well, you know you have no jurisdiction, stop wasting time. I think that was an attempt to prejudice the minds of the public in the event of a ruling against them, which was very unfortunate, because too often in the Caribbean, too often in CARICOM, we have sought to delegitimize our institutions like the CCJ because politically it's convenient. And that was another clear example happening with this judgment. I've read the judgment. I heard the gentleman ask you about the judgment. The judgment is a fundamentally important judgment. It reimposes and reinforces and gives the full authority of the final court to the rule of law and to the duty and obligations of the institutions of Guyana, Trinidad, Dominica, wherever, that they must comply with the constitutional provisions enabling powers and restraints, whether you're the executive, legislature, or the judiciary. And you cannot decide to just read into the Constitution or read out of the Constitution what you see fit to be able to tailor a case before the court. And it's a very powerful judgment, and it reinforces that what was attempted through the judicial process and the Court of Appeal was contrary to the structure, the intent, and the purpose of the constitutional provisions for electing the president.
So Kirk, just to delve into the specific question that you asked, the ruling specifically states that not only was the appeal granted, but the decision of the Court of Appeal was made without jurisdiction and is invalid and of no effect. And the court declared that the report of the Chief Elections Officer of June 23, 2020 is similarly of no effect. As a parallel to that order, that's a affirmative order, and we've read in other parts of the press that the court has made no coercive orders, but rather we are of the view that there is an order that changes the CEO's report and removes it entirely from the table. The court also provided invaluable guidance as to how the chief election officer must come to his result and what is then required after that result is declared should a party be unhappy with the outcome. And in essence, the court has said that all matters that are contended are matters for the elections court and must be dealt with through an elections petition. And of particular significance, we are now going through the judgment, is paragraph 47 of the judgment, which I just wanted to read quickly. By the unnecessary insertion of the word valid, the Court of Appeal impliedly invited the CEO to engage unilaterally in a further and unlawful validation exercise unknown to and in clear tension with the existing constitutionally anchored electoral laws. That further exercise, which the CEO was quick to embrace in breach of the Court of Appeal's stay of proceedings, also had the effect of facilitating a serious trespass on the exclusive jurisdiction of the High Court established by Article 163. The idea that the CEO or GCOM could, in an unaccountable, non-transparent, and seemingly arbitrary manner, without the due processes and legal standards established in Article 163 and in the Validation Act, disenfranchise scores of thousands of electors is entirely inconsistent with the constitutional framework. Whatever allegations of irregularity attended those votes, and the court expressed that they neither agree nor disagree with the existence of such irregularities, as that determination could only be made at a later stage, we must be adjudged by the High Court under Article 163, as correctly stated by the chairperson of GCOM, that these matters are a matter for the High Court to hear. And when you read, that's just one excerpt of a very powerful and tightly written judgment. I certainly believe that there is a clear pathway now as to what has to happen next, which is the Chief Elections Officer must act on the instructions of GCOM, whether he likes it or not, must adhere to the law, and there will be a declared winner. And should there be merit in the allegations that have been put forward, those allegations will be dealt with at a separate stage. And as for everyone there that's listening with respect to how fast the court system is moving, we certainly as practitioners here take solace that if the allegations have, these matters will be quickly adjudicated upon. just as the matters that have been before the court over the last 4 months. The several matters have been adjudicated upon with finality. So as we see it, the process has been laid out as to what has to happen next.
Thank you, Mr. Kissoon. I'd like to bring Senior Counsel into the conversation because we've seen the process being laid out before in terms of what the Commission and the Chief Elections Officer ought to do. And we've seen a divergence from that established guidelines. Are there any grounds now that the CCJ has ruled on which the Chief Elections Officer can continue to push the numbers that he has put forward in his most recent report, in his latest report?
No, because the CCJ declared that his report that he handed in with extraordinary speed after the decision of the Court of Appeal.
And if he attempts
that, also had to, well, I mean, could somebody be so brazen to just submit the same document again? I mean, I don't know. I don't know the guy. The CCJ said that the judgment of the Court of Appeal on which the Chief Elections Officer relies is null and void. They also took the extraordinary due process step of saying that his report is also null and void. That means there's no legal basis whatsoever. There's no longer a Court of Appeal decision in existence that he could rely on to try to pull that sort of stunt again. It's as simple as that. He now has an obligation to present the quantitative result of the count, because as the Chief Justice, as the CCJ said, and my learned friend just read, the core issues of these allegations can only be determined in accordance with the election jurisdiction process. That process can only be triggered by petition once GCOM declares the result or the winner based on the quantitative report from the supervisor of election. And thereafter, with the election petition, all of the other qualitative issues of fraud, residence, and so on can be determined. So there's no lawful basis, there's no legal basis upon which he could try to do that again.
Thank you. Mr. Kissoon, more specifically, a meeting of the Commission has been called for tomorrow at 1 o'clock. Could you say, in your opinion, what we could expect to come out from that meeting? And do you think the chairperson of GCOM should have already instructed Lowenfield once again to deliver his report based on the recount figures as she did earlier in June?
No, I'm only going to speak to the legal parameters and what the facts are before, and not offer a view as to what ought to happen. The chairman's instructions to the Chief Elections Officer in her June 16th letter are clear and remain valid and in full force and effect. I suspect that this meeting has been called for the purpose of ensuring that those instructions are again transmitted or properly received from the Commission, and it's not the chairperson's instructions on her own. The Commission has decided to issue those instructions to the Chief Elections Officer. The Chief Elections Officer is under duty. The duty first emanates from the Constitution under 162 and has been codified in statute in the Elections Amendment Act of 2000, Section 8 of that Act, under duty to follow the instructions of the Commission. And not only was that duty set out in that Act, but it was also affirmed in the Order 60 of 2020, where it said, for the avoidance of doubt, the Chief Elections Officer is under the direction and control of the Commission. The Chief Elections Officer would, as I'm sure he would, follow the instructions of the Commission. The Chief Elections Officer last time prefaced his report on a state judgment of the Court of Appeal. There is nothing now to prevent him from complying with his duty. And once he presents his report, and this to be clear, that report is simply for the purpose of allocating the seats in the National Assembly. The tabulation exercise has already been undertaken statistically, and those reports are before the Commission that accurately reflect the recount results. Thereafter, the Commission will declare the results, and the processes will then continue from where they ought to go. And that's it in a nutshell.
Thank you very much. I'll go back to Senior Counsel. You spoke earlier about how extraordinary the Guyana elections impasse and the associated court cases have been. What does all of this mean for the region as a whole?
It's a lesson. It's an absolute lesson as to what you should not do if you want to maintain the integrity of your parliamentary and democratic and election process. I mean, you cannot have the entire region and the international community and all the observers speaking at one, including former prime ministers who have experience, enormous experience in the conduct of elections and in the conduct of the counts, speaking pointedly about the validity of the process, but expressing grave concerns about the count and the statement of the poll, etc. Right? And then finding, and in the face of the court of the CCJ's judgment, I'm free to say it, finding all sorts of machinations to avoid the inevitable, meaning the inevitable result, the inevitability of the implementation of the count, the mathematical count, the report to the GCOM declaring the winner, and any question concerning whether there was a free and fair election, whether there was fraud, whether there was this, being a matter to be determined by the High Court. What the Guyana experience tells us in the Caribbean, that there was every attempt to find every other source of satisfaction, rather than the one which the Constitution gave all of the Guyanese people and all of the Guyanese politicians. If you have an issue with the validity of the election, you cannot go to the supervisor of election, you cannot go to GCOM, you cannot go to the returning officer. You have to allow the count to be implemented by GCOM, and then you go to the High Court under the election jurisdiction of the High Court that has the exclusive jurisdiction in accordance with the law, tradition, and it's elementary for anyone with understanding of the election jurisdiction, because the election jurisdiction of the court was a parliamentary one. It was Parliament who decided these issues in the days of old. That parliamentary jurisdiction was passed to decide whether somebody should sit because of a free and fair election account, was transferred to the High Court. It was never transferred to GCOM or the supervisor of election, or to the supervisor or to the returning officer in District 4. And many of us in the CARICOM and the OECS with some experience in election matters were a little troubled by these acts. That's one of the reasons why when I was asked to be a consultant or to assist, I readily agreed, because I think this time I wanted to be on the side of what I thought was right. For a change, maybe.
Thank you very much. After 4 months of waiting for a declaration of the elections results, more than 4 months, persons are now asking, is it really over now that the CCJ has ruled? Is it final? Are we going to get a declaration and conclude the electoral process? That's the question I want you to answer from a legal perspective.
Well, that's a fundamentally important separation of powers question. When the court rules, as the CCJ has ruled, with the greatest possible clarity, but force, it is a matter now for the executive, the president, his attorney general, the cabinet, to decide in the interest of Guyana whether they intend to comply with the rule of law, with the inevitable consequences of the decision of the CCJ, which is what any executive should do, properly, prudently, and lawfully, comply with the orders of the court, and try not to continue this whatever. I don't want to use any words for people to accuse me of interfering in Guyanese politics, but this exercise that has been going on for the last 4 months or 100 years, the court has made a clear ruling. The Chief Justice said the law must take its course. One of the causes or one of the consequences of a decision of Supreme Court like the CCJ is that the executive has to decide to accept the ruling and the consequences of the court. Otherwise, the administration of law and the rule of law is going to be dragged into the gutter. It is going to be made a mockery of the jurisdiction of the CCJ's court. And there is no other place that they can go now with this ruling, except to make a decision in the interest of the people of Guyana to comply with the ruling and the inevitable consequences of the CCJ's ruling. There's no other place to go. The separation of powers, my friend, principle requires the legislature, the executive, and the judiciary to comply with the provisions of the Constitution, and more importantly, the rulings of the High Court and the rulings of the CCJ, the Apex Court, on what in fact the Constitution actually means, that GCOM, the supervisor, the returning officer, had no authority to do what they did, neither did the Court of Appeal, and therefore the process must be now. The supervisor gives his report on the mathematical count, that if there's any further issue concerning or questions concerning the count or the conduct of the election, that has to go to the High Court in the exercise of its election jurisdiction. That is the only possible application of the separation of powers in Guyana right now.
Thank you very much. Mr. Kissoon, do you have anything to add? And I'll also invite you to offer your closing comments.
Well, just to say that it was a tremendous privilege for us to work with all of the parties involved in this matter, both on the part of the bench and the bar, in having these matters heard quickly and effectively. It was working with Mr. Mendez and his team. On behalf of my co-counsel, Anil Nandalal, and myself, we would like to thank him for his guidance and leadership in helping us go through this, and as well as the Counsel Astaphan for his support. I certainly jumped to the opportunity to share a platform with him, and we look forward to having as he said when we spoke earlier, a nice cold Guyanese rum when this is over, simply to celebrate the fact that it will be over, whenever that may be. But Kurt, thank you very much for this opportunity, and with that, I would like to close.
Thank you, Senior Counsel. Any parting words?
No, except to say that I was quite happy to assist in this matter. In fact, I was privileged to assist in this matter because I saw it as a matter of historical constitutional importance. And I was very happy to work with everybody.
Thank you very much. Mr. Kissoon.
On that note, certainly, as with every court case that I've sat in, parties are happy and unhappy with decisions. I returned to Guyana here 5 years ago. A little bit about myself. I grew up in Mackenzie. My father was a mining engineer in the bauxite mine, and I went to a To Ccj school and left and came to Georgetown. My father's from Ansgrove, and I moved to London and eventually made my way back to Guyana. There's one theme about Guyana and Guyanese, and the CARICOM as a whole, is that we are united people. We may have different cultures and we may have different traditions, but without any doubt, certainly share one common objective, and that's for a better life for all of us. And I look forward that regardless of whatever differences may exist legally and in society, that these matters do come to a close. And if they are unable to come to a close that is satisfactory to parties, rest assured they still have recourse to the courts, and the courts can ultimately deal with these matters. But we as a country have a very important role ahead of us, not only for economic stability, we need to address that urgently, but to deal with matters of health, and as well as to rise to the Caribbean stage, to show what every Caribbean national already knows, the Guyanese are the best at what they do and have been doing it the best out of Guyana. It is now time for us to show that it is also being done within Guyana. And that is simply my message for everyone that's listening.
Thank you very much, 20th Lord Devindra Kissoon. And we were also talking with Senior Counsel Anthony Astaphan. Thank you very much, both of you, and have a pleasant rest of the night.
Thank you, Kurt. Good evening.